So we've talked about character evidence in the introductions to this segment, and you've learned that there's a basic prohibition on introducing evidence of things in the past to show that the defendant conformed with those things in the future, or that any party, plaintiff, prosecutor, plaintiff, or defendant, civil or criminal. And we learn in the Michelson case that the reason for that is, and I've alluded to this in some of the videos earlier, is not because we think the past is irrelevant to the future. If you were hiring someone for a job, you'd certainly want to know how they'd done previously. If you were hiring someone, you may want to know if they've got a felony record, because we do believe in almost everything that the past has some salience for what people do in the future. But in the law, we have a general sense that we shouldn't consider that because we may over-rely on it. At least that's what Justice Robert Jackson said in the Michelson opinion, that we might just, once we know that a person has a criminal record, we might just assume, well, there they go again, and not worry about looking at the particular facts. So Michelson tells us that the law has a notion that we don't do this. But it also says that because of the unique nature of criminal cases, that we will in fact allow a defendant, if he or she so chooses, to present evidence of his or her good character. Now, as Justice Robert Jackson tells us in the Michelson opinion, you really very seldom ever want to do this. Why is that? Because the nature of the rules of evidence are such that if you choose to do this, the vehicle by which you get to present your good character is extraordinarily limited. You only get to have a witness come and talk about either your reputation in the community for good character, honesty, law-abidingness, etc., or under the modern rules, reputation or opinion evidence. Either I know as a character witness that the defendant has a good reputation for honesty, or that my opinion of him is that he is an honest person, is a law-abiding person, wouldn't steal, is a non-violent person. I can talk about either the defendant's reputation for these traits or my own opinion of him or her for these traits. And that's all I get to say. Think about how poor that evidence is. Imagine if you came to me and wanted me to write you a letter of recommendation for a clerkship. And I said, my opinion of this student is that he or she is hardworking. Sincerely, Wesley M. Oliver, professor of law. Would you think I had done a good job in that letter of recommendation? My guess is you wouldn't, because it's the details that make something like a character reference really sing. Well, when the defendant goes to present his evidence of good character, he doesn't get to do that. He only gets to say that a witness who comes forward can testify to the reputation or opinion for the general character trait. And as Justice Jackson talks about in Michelson, this comes at great cost. Because now that the defendant has put his or her character at issue, the prosecution gets to do several things. First of all, the prosecution can offer character witnesses of its own who will come forward and say, no, the defendant's reputation in the community is not for honesty, but rather for deceit, is not for peacefulness, but rather for aggression. And the defendant's character witness can now be cross-examined on all sorts of things. Are you aware that there are rumors in the community that the defendant committed X or Y crime? Are you aware that there are those in the community who think the defendant has a reputation for dishonesty and for aggression? Are you aware that the defendant was twice convicted of the following crimes? Are you aware the defendant was arrested for these crimes? Once you put your character at issue as a defendant, all of a sudden now you open up for cross-examination those witnesses who are attesting to your character to make sure that, or the cross-examination will ensure that that witness actually knows everything there is to know in making his or her assessment. And we get to evaluate whether the witness is a good assessor of opinion, and or whether the witness's opinion is well advised. So we get to in cross-examining this witness, delve into all sorts of things. We get to look at those details. Are you aware of these arrests? Are you aware of these convictions? Are you aware of these other rumors that are out there? And in doing that, in inquiring into the witness's basis of knowledge, now all of a sudden, everything that the defendant has done in his or her past that might negatively bear on the character trait that's being testified to comes out. All those details that were deprived of the defendant in attesting to his or her good character, all those details that are contrary to good character will come out and as part of the cross-examination, in addition to the fact that the prosecution can now call witnesses to the negative side of the defendant's character through reputation and opinion. The conclusory stuff that the defendant presented, the prosecution can present the same conclusory stuff and then delve into the details on cross-examination of the defendant's character witness. So as Michelson says, it's a really rare day when the defendant will ever want to make his character an issue and do so in this manner that is highly limited for the defendant and opens up all sorts of avenues of attacking the defendant's character for the prosecution.